Well, Counsel, it does seem to me that the court does have discretion under 7 to do what it believes is appropriate in a given case. And if I look at subpart 1, one of the options is to transfer the lawyer to disability inactive status. Another is to, under subdivision 6, is to appoint a referee to make findings and recommendations regarding the disability allegation. And the conversation that we've just had, I think, bears on the concern that I have, and I think what Justice Paul Anderson raised, is how do we protect the public and how do we protect the client in a specific situation where we have to first look at whether there's a disability and make some determinations as to the proper procedure, and that bears on whether the lawyer is unable to represent their own interests and whether they're able to represent clients. But it seems to me that we're at the earlier stage of this proceeding trying to determine whether there's sufficient evidence to move this forward to the next step. And that's what I'm trying to figure out is what these next steps might be.
Mm-hmm. Your Honor, let me respond by indicating what we believe the next steps are, and then please let me know if I haven't addressed that. The first step would be to place respondent on disability inactive status. That was the referee's recommendation for the reasons he cited in his memorandum, which I've already talked about, and I won't reiterate. The second step would be a stay of the disciplinary proceeding, or actually those would probably be simultaneous actions. At that point, the respondent lawyer would not have to deal with the disciplinary proceedings. They would not have to appear at a hearing. They wouldn't have to respond if there were a new complaint to notice of investigation. Matters would be placed on hold. The next step would be initiated, and this I think is an important point, the next step would be initiated by the lawyer. When the lawyer believed that he or she was now competent, capable, able to move forward with the practice of law, and if respondent concludes, and I'm not sure what respondent's argument is going to be as to disability as of today, but if it's respondent's position that there were issues, they've all been addressed, I'm ready to move forward, I can represent clients again, I can participate in this disciplinary proceeding, respondent could file that petition this afternoon. That would be the timing. The next step would be the petition for reinstatement. As part of that process, then, we would undergo an investigation, an independent medical examination would be undergone, further medical records would be obtained, we would have a better handle on the exact nature of what the disability was, and also whether that disability had been addressed or no longer existed, whether the respondent, the lawyer, again, petitioner in that context, whether the petitioning lawyer was now able to move forward and competently represent clients and participate in her own disciplinary proceeding.
Counsel, and I'm looking at the referee's order, and I'm looking at paragraph 1.
The very first page, Your Honor?
It's page 6.
6.
And that is where the recommendation is that the attorney be immediately transferred to disability inactive status under Rule 28C. But the clause that strikes me is due to respondent assertion of disability and her ability to assist in her defense. As I read that, it appears that the referee is making the decision solely upon the respondent's assertion of disability and her assertion of her inability to assist in her defense. So if the attorney makes a representation today, I'm not disabled, I am able to assist in my defense, are these conclusions insufficient for us to go forward?
I do not believe they are, Your Honor. And I think, respectfully request, we have to look at the referee's entire recommendations. He does talk about the respondent's assertion But he also talks about on page 1, he notes that respondent's husband had locked her out of her email accounts and computers and had restricted her business telephone access so she would not be able to deal with clients. He noted that respondent's true condition on page 4 had been undiagnosed for several months and manifested itself in several symptoms, calling into her ability to represent clients. I see my time is running up, but there are page 4, page 5. I really think we have to read the referee's recommendations in their totality, and clearly there is a much broader basis for his conclusion that respondent, or his recommendation that respondent.
Well, then why isn't it in 1, 2, and 3 here if that's the, I mean, you know, you can cite all kinds of things that are in the record, but, I mean, you're basically telling us that we can make an independent conclusion based upon the record and not bound just by this language here? Is that what you're telling us?
No, Your Honor. I think what I'm suggesting is that the referee's formatting may be not as precise as the court would prefer, as the court would use, but if we read the referee's recommendations and conclusions in their entirety, it's pretty clear that the referee's recommendation is not based just upon respondent's assertion, but it's based upon the totality of the information the referee had before him, heard from individuals, you know, the whole process that this court expects a referee to go through at a hearing, and it was based upon all of that that the referee made his recommendation.
Thank you, counsel. Your time has expired. You have 10 minutes for rebuttal.
Thank you, Your Honor.
Ms. Longry.
Good morning. Thank you, Your Honors, for this opportunity to respond to the referee's recommendations. As defined in our memorandum, this matter at hand is not appropriate, we feel, for a Rule 28 disability issue, but instead is really more of a matter of a request for reasonable accommodations. Back in June, I want to assure the court that I never brought up that my client was claiming disability under Rule 28. We were simply requesting a continuance because she was in the hospital, and as indicated by my subsequent letter, medical issues sometimes change, and her doctor indicated that she would be ready to go back to work once she had an opportunity to adjust to her medication. Now, this issue today is whether or not Ms. Clark is able to assist in her defense. And Ms. Clark is able to assist in her defense, and she is going to give the remainder of our argument.
It seems to me that it goes to that question, but it also goes to ensuring that her clients are protected.
That's
that she is capable of properly representing her clients.
And I think that the issue at hand is whether or not, first of all, if she asked for accommodations or if she requested a disability under Rule 28, and whether or not if she's able to assist in her defense. And as I indicated, Ms. Clark will give the remainder of our response because she is the attorney who is here to demonstrate that she can assist in her defense of her case. Ms. Clark.